Hello, welcome to your online lecture for legal liability. I'm Dr. Cosby. I'm excited to be talking through this topic. I will say right away, I am not a legal expert. I'm not a lawyer. I can only give you legal terms and definitions as it relates to the field of athletic training. Some of these definitions and terms will transcend into other healthcare fields, but I'm really specifically just talking about the field of athletic training. I tried my best to put my face on the screen so y'all could see me while I was actually presenting, but anywhere I put the video feed, it covered parts of the PowerPoint. So you can imagine me sitting behind my desk right now, really being excited about this topic. So one of the things that I wanted to start with as we begin this very kind of sensitive, touchy topic is the reality that you're moving into the healthcare field. You're getting ready to transition, to practice, to leave the program, and to actually be a professional. Most of you in the field of athletic training, some of you will go on to further graduate school where you might become a physical therapist or a physician assistant or even a physician, right? But either way, it holds true that because you are moving into the healthcare field, you are now going to be held accountable for any decision, any action, any treatment, any rehab, any decision to return an athlete to play. You're going to be held accountable for all of those decisions, right? Right now, it's typically your preceptor or your clinical site that can be held liable for any decisions that are made. But essentially, you're going to leave us and you're going to go and move into your own realm of clinical practice, and the decisions that you make, all of the decisions that you make, ultimately may come back to have an impact on you legally. So as we start thinking through legal concerns and legal issues in the field of athletic training, I kind of want you to keep that in the back of your mind that any decision that you make, your patient has 1 to 5 years, depending on the state that they live in, to come back and say that you're the reason that they now have chronic knee pain, or you're the reason that they now have chronic headaches because you returned them to play too soon following an MTBI. So the potential always exists for athletic trainers to be sued, for your athletes to come back and claim that you either did not do something you were supposed to do, or you did more than you were trained to do over time. So it becomes important to understand the legal terms. And there are 2 legal terms that we're going to talk about right away. They are malpractice and negligence. And oftentimes those terms are used interchangeably. And I would say that malpractice would be the more appropriate term to use for healthcare professionals. So we think about malpractice, this is going to be a more specific term that really addresses standard of care. And standard of care, that term is most often applied to healthcare professionals. Whereas negligence, which, I mean, if you look at the definition of malpractice, the term negligent is actually in there. But when we think about negligence in general, it's a catch-all term that is most often used to assess a person's carelessness, a deviation from the standard of care, but it encompasses both non-medical personnel and medical personnel. So it's not really just taking into effect a healthcare practitioner, it's everyone, right? And so the more proper term to use in healthcare would be malpractice, right? And when we define malpractice, you can see that definition here on the slide: improper, illegal, or negligent treatment that you perform, which is then somehow associated with a negative or adverse outcome or effect for that particular patient. And that could be a short-term outcome or adverse effect, which means they lose a season, which in professional setting means they lose money, right? Or it means that they graduate and they leave you, and now they're suffering from chronic issues or chronic pathologies, right? Ultimately, when we think about malpractice, the courts are defining that as failure, right, of a professional medical individual to act in accordance with the standards of care, right? So that goes back to the NATA Code of Ethics, that goes back to the Board of Certification Code of Ethics, that goes back to becoming licensed in your particular state and understanding the legal or the laws and knowing how to treat patients in that particular state, right? So when we think about malpractice, what we have to be thinking about anytime we treat a patient is, are we doing what we are trained to do, Or are we moving outside of the scope of our practice and doing things that we maybe haven't been trained to do or haven't received an external certification to do? So there's a list of different things or different ways that malpractice can occur within the field of athletic training. So I'm going to skip to the next slide and really talk about examples of malpractice in athletic training that are probably 5 of the most common. The first one is failure to prevent injury by permitting an athlete to participate when he or she is not medically qualified to do so. So an example of that could potentially be, and we see this most often in the field of athletic training, with return to play after a mild traumatic brain injury, right? Sometimes the lines are blurred with the signs and symptoms that the patient might be presenting with, and we need them to return to play sooner, so we return them to play sooner, right? And overall, that leads to more long-term symptoms that patient may go on to experience. That would just be one short answer. And even, I think, maybe more common example would be return to play too soon after an ankle sprain, right? We return that patient to play after an ankle sprain. The ligaments aren't completely healed. Now that patient goes on to suffer from chronic ankle instability and maybe osteoarthritis in the long term. At the high school level, bullet point number 2 is a big deal. It is the recommendation in the state of California, and as you move outside of the state, I think most states require an ambulance to be at football games or at any contact sport that is outdoors. And so you'll see in most football games in the high school setting, an ambulance just parked in the corner of the field. The idea is that if we have a catastrophic, right, or traumatic injury, EMTs, paramedics are on the site and ready to care for any emergent situation. If you don't have an ambulance, then the standard should be that you should have a team physician at least high school football games, right? And so when we fail to do that, if an emergent condition arises, we could be held liable. We'll define liability on the next slide. We could be held liable for anything that happens to that particular patient. One thing I think you've learned a lot about over time is action plans. I assume that anytime you move to a new clinical site, you are required to kind of see if they have action plans for each of the different sites, athletic sites at the clinical site. And so knowing the action plans, emergency action plans for each of the fields or sites that you might be at will be extremely important. In fact, we've seen clinical sites be sued because they didn't have an emergency action plan. And in fact, now they have an emergency action plan because they were actually sued, right? Another one is a failure to identify a condition. So I'll talk through 2 different types of conditions. You can have environmental conditions, right, which will, may increase the risk of injury or health or disease to the patient. So high heat index would be an example of that. Failure to recognize that it's too hot for your patients to participate would be an example, or it's too cold to participate. That's one set of conditions. Those are going to be environmental conditions. Another type of condition are previous historical illness, disease conditions. So you have a patient who maybe has a familial history of some type of cardiac disease. You fail to screen that patient, and that patient, let's say, suffers from sudden cardiac death would be an example. And then last but not least would be the failure to examine an athlete properly after an injury. This is why it's so important that you treat every injury, regardless of how it presents to you, the same. And so an example would be, let's say a patient comes in, they say they took a blow to the chest, they don't have any palpable pain, and you're like, okay, no big deal, they don't have any difficulty with breathing, and so you return them to play. They go home and maybe they suffer from a pneumothorax, right? Because you didn't do the auscultation assessment or you didn't do the breathing assessment, and so now they have this more catastrophic injury and or illness. So these are all examples of malpractice in the field of athletic training where you could be held liable. And so the legal definition of liability is that you are legally responsible for the harm that was caused to another person. So you are the reason. Either you act outside of the scope of your practice, or maybe you perform the skill, but you didn't perform the skill the way that you were taught or you were supposed to, and so you caused harm. But now you are legally being held liable for any harm that the patient actually exhibits as a result or lack thereof of the treatment. So here's negligence. I kind of talked about it a little bit. It's going to be the catch-all term, which encompasses both non-medical and medical individuals, right? It's failure to use ordinary or reasonable care, right? So at least to treat the patient with the normal standard of care that's expected of an athletic trainer in that particular state, right? So every state is going to be different, which is why you have to understand the state practice acts that you are moving into. So moving into Arizona, you need to understand your state practice acts, and then you act according to that level of standard of care or expectation for that particular certified athletic trainer. If you move to Pennsylvania, for example, the standard of care is going to change based on the laws that are there. So you have to make sure that you truly do understand what's expected of you in each of the states that you decide to move to. Now, in order for a person to actually sue an individual and claim negligence, in other words, we didn't do what we were supposed to do, or we did something outside of the standard of care, there's a checklist of things that they have to provide in order to win a case, right? And so that's kind of where we can take a deep breath, because oftentimes when a patient sues us for negligence, oftentimes they're missing one of those things. So the checklist of items, they're listed here. So we have duty of care, breach of duty owed to the patient, the foreseeability, causation, and injury and or damages. And the one thing that I want to say is they're kind of all really linked. So if you see kind of a break or an inability to provide evidence in one of these areas, most often the negligence case is dismissed. So again, this is a benefit for the healthcare practitioner. But let's define them pretty quickly. You have a duty of care, which to me, I mean, that makes pretty good sense, right? You have a duty to care for the patient that is walking into your clinic and is injured, right? What a judge is going to ask is whether or not you owed a duty to actually care for that particular patient. So in most negligent cases, the duty of care is the one piece that is usually the checkbox. In other words, it's the one piece that kind of starts or catapults the negligent complaint. So an example of this, we'll take a patient who suffers from a head injury. Patient comes in during practice. They complain of dizziness after taking a hit. You have a duty to evaluate that patient, right? And if you don't evaluate that patient, or maybe you send them back to play and then they come in after practice, right? There's this duty, inherent duty that exists to evaluate any patient that walks into our clinic complaining of an injury. And that's a duty that we have. It's a duty that we take. It's within our standards, both the NATA standards, Code of Ethics, and the Board of Certification Code of Ethics. But oftentimes, when we're overloaded, right, or when we have a mass of athletes in our clinic, sometimes our duty of care may be compromised, right? And it's in those moments where our duty of care is compromised that we increase the risk for litigation in terms of negligence, right? So the first question that the judge will ask is, did you have a duty to care for this particular athlete, right? And the answer most oftentimes is going to be yes, especially if that athlete is your athlete, the athlete that's under your direct care. Now, there are some times where we might have visiting teams who travel without athletic trainers. And so the duty of care can be questionable. Do you have a duty to care for the visiting team athletes? And I would say that the answer is most often yes, especially if the visiting team's athletic training staff calls you and asks you to be responsible for them. There's a small percent of time where maybe you don't have a duty to particularly care for them, and that's if the athletic training staff does not communicate. But once an athlete from a visiting team walks over and asks for help, you certainly have a duty to care for that visiting team's athlete. So that first question is, is there a duty owed to the patient for you to care for them? If the answer is yes, which most oftentimes in the field of athletic training, it's going to be, the next question is, did you breach that duty? So it's not enough for a person to just say, I walked into the athletic training clinic, they didn't treat me, now as a result I have these injuries. It's not enough for them to say that. The next question is, did you breach that duty? And so what does it mean to actually say someone breaches? Well, to breach means you just failed to provide the standard of care what a reasonably prudent athletic trainer should provide to an athlete with an ankle injury or with a head injury, right? And that goes back to our scope of practice. So as long as you're practicing within the scope of your practice and you know your state practice acts, most oftentimes you won't breach that duty, but there are times where athletic trainers act outside of the scope of practice, and in fact, they had a duty to care. They cared, but they breached that duty. They didn't provide what a normally reasonably prudent athletic trainer would have provided if they were their student athlete. The third term is what we call is foreseeability. Does the breach of duty lead to foreseeable events? So an example would be if we have a patient with a head injury, if we don't evaluate them and we send them back to practice, what things could be foreseeable? Maybe long-term memory loss, maybe long-term sufferage of headaches, etc., etc., etc. So that term foreseeability is when we breach that duty, if we were to think as a healthcare profession, what things could we foresee might happen to that particular patient? The fourth term is causation. So not only do we have to have a duty of care, and not only do we have to breach that duty of care, the next thing that we have to think about is causation, right? And so in other words, did the breach in duty actually cause the next step, which are the injury or the damages that the patient is actually going to suffer from? And the injury or damages part is a little bit tricky in terms of what we're thinking about. This is the piece where we say that you are legally responsible for the harm that was caused to that particular patient, right? So an example of that might be you have an ankle sprain patient, 5 years later they develop osteoarthritis because you let them play on that sprained ankle over and over and over again, and as a result they have medical bills. So the injury and the long-term damages are as a result of your lack of duty of care, the breach of duty, and then your lack of ability to see over time what might happen leads to these injuries and or damages. So these are the components of negligence. Most often you're asked to do like a multiple select where you're selecting all of the components in a negligent case that must be met in order for an athlete to actually sue you for the term negligence. Tort is a little bit different in that we committed these legal wrongs against a person, right? We get there, we go back to this slide and we say, okay, we've breached the duty. Our breach of duty has caused some sort of injury or damage to that patient. That could be lifelong injury or it could be short-term injury. And now we're at the place where the legal system says, and here's what you're actually going to pay, right? So when we breach our duty, whether that's intentionally or by negligence, if we cause harm, the court says, here's the amount of money that you're actually going to pay. So the tort kind of, in some essence, represents the financial obligation that we now have to the patient that we've harmed as a lack of our conduct or as a result of not treating that patient the way that we were trained to treat them. So there are different types of torts, and yes, you will be tested on these. The first is nonfeasance. I like to call that omission. So this is when an individual fails to perform a legal duty. So something that they are expected to perform within the scope of their practice, they just don't do it. So another way to say that would be omission. In other words, you do nothing. O means without, so you're not doing anything. An example of that would be you not attending practice or a game without a justifiable reason or without a replacement, right? Another example of that would be maybe not referring an athlete out to a physician or a neurologist when you see certain types of signs and symptoms. So you just fail to act, essentially. That would be nonfeasance or omission. Then you have malfeasance, and so you commit an act that is not legally yours to perform. So you're acting outside of the scope of your practice. That would be an act of commission. You actually do something, but you're doing it outside of the scope of your practice. An example of that is applying sutures or stitches, or you clear an athlete or individual from a concussion when they're under the care of a physician. Let me be clear on that. So those would be examples where you're acting, but you're acting maybe outside of the scope of your practice. And then you have misfeasance. You improperly do something that you actually have the right to do. This is the worst type to me. So an example would be maybe you don't irrigate a wound as much as you should. Maybe you put, I don't know, an ACL brace on, but it's not on right. And as a result, that patient damages the knee more. So you have the skill, but you just don't perform the skill the way that you're supposed to, and that leads to damages. So there's different types of torts that you can be responsible for. Probably the worst type of tort, I mean, this is just, in my opinion, is a misfeasance, because you have this training, and when you don't do what you're trained to do and that leads to further injury, I don't know, that just makes it really easy for the athlete to really make a case for negligence. But these are the different types of feasances or types of missions, and they're important to understand in terms of the terms. So there are certain laws that do protect us as healthcare practitioners. One law that you do have to know and you're responsible for knowing is the Good Samaritan law. Believe it or not, this does change from state to state, so it will become important to understand the Good Samaritan law where you live. I have actually searched high and low to find the California Good Samaritan law, which was really enacted to protect those individuals who were not on duty, to encourage them essentially to help patients that they might see off duty, right? And so in the law, I'm going to read no person who in good faith and not for compensation, so you can't have been paid, renders emergency medical care or non-medical care at the scene of emergency shall be held liable for any civil damages resulting from any act or omission. So in other words, if you are working at the scene of an emergency and you truly are doing the best that you can do, as long as you are working within the scope of your skill set, you can't be held liable essentially for any damage or harm that you might do to that patient, right? So the goal was essentially, it was emergency providers. Oftentimes there was this fear that when they were off duty, that they didn't want to respond to an emergent situation because they could be held liable. Maybe they didn't have the same tools that they would have in the rig. And if that patient dies, they don't want to be held liable. So the intent was really to encourage emergency responders to respond while off duty to help individuals. And this has been an amazing law because it really has reduced the litigation that occurs for Good Samaritans who are trying to help individuals in an emergent situation, but may not actually be working at the time. So what do you think? A baseball pitcher was struck with a pitch ball directly in the orbit of the right eye and fell immediately to the ground. The athletic trainer ran to the player to examine the eye. There was some immediate swelling and discoloration around the eye orbit, but the eye appeared normal. The player insisted that he was fine and told the athletic trainer he could continue to bat. After the game, the athletic trainer told the patient to go back to his room, put ice on his eye, and check in tomorrow. That night, the baseball player began to hemorrhage into the anterior chamber of the eye and suffered irreparable damage to his eye. An ophthalmologist stated that if the patient's eye had been examined immediately after the injury, the bleeding could have been controlled and there would not have been as much damage to his vision. So, what do you think? If the patient brings a lawsuit against the athletic trainer, what must the patient prove if he is to win a judgment? I want you to take a pause here. I want you to write kind of those 4/5 elements of negligence, and I want you to really think through whether or not you would be held liable and whether or not you would have to actually pay a tort, maybe even what type of tort, malfeasance, misfeasance, etc. you think occurred here. And I want you to email me that so I know that you're actually listening to this online lecture. Okay, certain things protect us from litigation. So the first is the statute of limitation. This kind of is what I love about litigation. It sets a specific length of time that an individual can sue for damages. And so it depends on your state, but that could be 1 to 5 years. In California, it's 5 years. So for those of you that are going to be practicing in California, a patient, the moment you treat them, they have 5 years to claim negligence on your treatment. Again, keep that in the back of your mind, like as you're treating patients, like, am I really making a well thought out decision that's within the scope of practice, right? As you get ready to transition to practice. So what protects the athletic trainer or the first responder, the student really in this case, there's this thing called an assumption of risk. So the most athletes in most clinical sites will have athletes sign what we call is an assumption of risk, which implies there's this inherent risk associated with participating in the sport that they're participating in, right? And this individual, through signing this assumption of risk form, either through express or implied agreement, assumes some risk for the danger that's inherent in that sport. And so what does that mean exactly? Most often when there's a negligence case, most often the athletic trainer isn't held 100% negligent and isn't responsible for 100% of the damage that occurs to that particular patient, because they assume the risk that is inherent in the sport, right? And if we think about salaries of professional athletes, we know that NFL athletes are some of the most highly paid athletes, right? Why? Because their assumption of risk is a lot higher than, let's say, I don't know, a golfer, for example, maybe a soccer athlete, because the risk of taking a blow at high velocity just increases the risk of death, of brain damage, of all of the other long-term diseases. So as you leave us, make sure, if you're working in a clinical site or if you're working at a high school, for example, to create with your legal team an assumption of risk form that either the student athlete or the student athlete and the parent sign, so that if we go back to that statute of limitations, let's say a patient decides they want to sue you 2 years later, you have this assumption of risk. So if nothing else, you're not held 100% liable, because the student athlete assumes some of the risk that would be inherent in that particular sport. Here's an example of an assumption of risk waiver. There certainly are other types of assumptions of risk forms. I think we are here at Point Loma have one. Most clinical sites have an assumption of risk, and universities, to be quite honest, right? This is always assumption of risk that's inherent in most of the things we do. Even for intramurals here on our campus, I think our students actually sign an assumption of risk form. Double check that, those of you that participate in intramurals. So now what I'm going to do is try not to belabor this, but talk about ways to reduce the risk of litigation. The first thing is establishing good relationships with your athletes. Obviously, if you're at the high school setting, and a key component is really good relationships with the parents, because most often when they're minors, the parents are driving a lot of the decision making, right? You have to have good relationships with your clients and then your coworkers. And your coworkers, they're going to include other athletic trainers, but it's also going to include your coaching staff and your athletic director. Having a great relationship with your coaching staff, your nurse if you're at a high school, your counselors, for example, it creates a better, communication pipeline, and in addition to that, it creates a support team for you should you be sued. The other thing that you want to do, and oftentimes our students aren't prepared to do this, but again, every entity that you go to will have a legal team. You want to establish specific policies and guidelines for operation of your athletic training facility or clinic, and then you always want to make sure that your athletic training clinic, when there are student athletes in it, is supervised at all times, so that if they get injured, you're able to see that. Same thing with equipment, bikes, for example, weights, all of those things. You want to make sure that you have supervision to reduce the risk of injury, which reduces the risk of litigation over time. Next, you all want to really truly develop, review, and follow your EAP or emergency action plan. I cannot say this enough. When we had our site visit, this is one area where we were dinged. We realized that some of our clinical sites didn't even have an emergency action plan. That emergency action plan is huge. In particular, when you do have an emergency, if you've practiced this with your team, then it is like clockwork. You call 911, you know where to meet the ambulance, you know where to direct the ambulance, you know the cross streets, which sometimes may change. So not only developing those, but reviewing those annually and going through those with your team annually will ensure efficiency in an emergency situation, and will reduce the amount of time that most people are spending because they're so nervous about the emergency situation. Okay. Another key component is becoming familiar with the health status and medical history of the individual athletes that you are assigned to. If you are a head athletic trainer, it will become important to know the health status and medical history of all of your athletes. So there's a difference, right? Like either you're an assistant athletic trainer and you just have your small group of athletes that you need to know medical history and health status of. if you're a head athletic trainer, there's just so much more that you wear. So those of you that want to go on to be athletic trainers, just keep that in mind. And then you want to obviously keep factually accurate and timely records. And I cannot say this enough. Your note taking, your record keeping is extremely important. We went through this, I think, in lower extremity, where we talked about not like erasing things in your note, just scratching through and initialing it. It becomes extremely important. But we are so prepared to present notes, like current notes. But how many of you, if you were to go to your clinical site right now and ask, oh, where are the records from 6 years ago? Some people have really good setup of records if they weren't electronic. Now that they're electronic, they're probably even more easily accessible, but understanding how to keep old notes or expired notes is just as important as keeping track of the current notes. Okay, next you want to document efforts to create a safe rehabilitation or training environment. And so one of the things, I think it's on the next slide too, that you're always going to do is make sure you're calibrating all of the devices in your clinic. So that includes therapeutic modalities, that includes exercise devices like upper body ergometers, bikes. Those all should be calibrated to make sure they are fully functioning correctly. Okay. Next, obtain from parents or guardians when minors are involved written consent for providing health care. If you are going to work in the high school setting, this is key. I remember when I was working in the high school setting my first year, I would have to call every single parent to just ask if I could touch their kiddo. And then I got smart and I created a written consent form which stated all of the things that I could be able to do. And I had the parents sign that form, so then I was able to treat their minor. So if you're at the high school, you're going to have this uphill battle. You verbal versus written. You always want written consent where you can do that. Always maintain confidentiality of your medical records. So in other words, your medical records should be locked and secured. You should never leave your medical records, whether that's on an iPad or a computer or a paper, out in the open for others to view. Exercise extreme caution in administration, if allowed by the law, of non-prescription medications. And I think this goes without saying. You all took pharmacology, so I hope that you learned that this is a big deal. There are a lot of student athletes who would love to get their hands on a whole full bottle of ibuprofen. And so knowing your state laws, some athletic trainers can't even administer drugs at all. So again, knowing your state law will be extremely important, and documenting what you're giving your student athletes will also be important. So make sure you're doing both of those. Use only those therapeutic methods that you are qualified to use. Again, this is all about knowing your state laws. Do not use or permit the presence of faulty or hazardous equipment. And I will say this, knowing that I've seen it done. Oftentimes, maybe we skip a year to get our devices calibrated, right? Because it's just an expensive process and we just can't afford it this year. Our budget got cut. Then we technically should take that therapeutic modality and put it in the back room and not use it, because the risk for it not functioning or malfunctioning and causing injury or damage is relatively high. So you reduce your risk for litigation if you just remove it from your athletic training setting. And I think I've talked a lot about interdisciplinary communication and the importance of interdisciplinary communication. So I can't say it enough. Having a great relationship with your coach, with your team physician, with local health care practitioners such as your physical therapist, whom you're probably going to refer out to, is just an extremely important tool to have, or skill set to have as an athletic trainer. If you have tools that you are not skilled enough to operate, then either having your workplace pay for you to get the certification will be extremely important to making sure you understand how to properly utilize that equipment. Do not allow injured players to participate injured unless they are cleared by your team physician. That is a double safety net, right? Okay, your athlete wants to participate injured, fine, let the physician clear them. Physician's going to make a lot more money than you, right? And so if they get sued, we're okay with that. So ultimately what I'm saying is, if you're unsure, have your team physician write the note of clearance. Again, develop an understanding with the coaches that an injured athlete will not be allowed to re-enter competition until the athletic trainer or physician has cleared them. And this will prevent a lot of the sideline chaos that we often see between athletic trainers and coaches, when the coaches just don't understand why an athlete can't return to play. But if we go back to the previous slide, what I said is making sure you have a great relationship with your coaches, making sure they respect who you are in your decision-making process. And then the next bullet point here is going to be that following the express orders of the physician at all times. So if you are at a college, you have indirect medical orders most often written by a physician. If you're at a high school, you may have direct medical orders, which means you have to call the physician every time. Some physicians actually write indirect medical orders. If you don't have either, do the indirect route. Have your physicians write everything that you can do so that if you're sued, you can refer back to this indirect document, which will then basically hold the physician liable, because this is what the physician has given you permission. One other thing that's really important is purchasing professional liability insurance. And I can't say that enough. I say it on another slide, but I can't say it enough here, that we are going to be sued. And sometimes we do make the wrong decisions, right? Or sometimes sometimes we choose the wrong treatment protocol, and that may actually cause more injury. That may happen, right? But having a professional liability insurance so that when or if you do get sued, it will support you financially is going to be extremely important. And then knowing your limitations. I think that's the big one. It's a hard one sometimes. It's a humbling one, right? Doing this legal lecture is very humbling because it's not within the scope of my expertise per se. So knowing your limitations and being okay with not doing a treatment that you can't do and referring out requires a lot of humbling, but certainly will reduce the risk of litigation and over time. So here we talk about professional liability insurance, and its major role is to protect you against any damages that may arise from injuries that occur while you are treating, right? It's going to cover you against claims of negligence, and so it's going to be the buffer that you need, especially since as athletic trainers, we're not making, six figures most of the time. So I want to show you what the liability insurance kind of looks like, or how to at least purchase that. So you'll know how to do that when you leave. There are several different types of liability insurance that you can use. The one that is supported by the NATA is HPSO. So I'm going to click there and it will take us to the website. And then from here, the question is, do you need a quote? Are you renewing a policy? Are you learning more? So we need a quote. And then the question is, are you a practice or a business owner? You are neither right now. You are just an individual who's going to be hired. Although if you start to work camps, you may create your own LLC, in which case you would click yes. But for now, we're going to click no. And then it'll say, let's get started. And I'm not going to go through the whole process, but I want you to see just how easy this really is. You can choose. It depends. If you graduate, then you're a professional. If you decide to do this, let's say today, then you would be a student. State of residence, I would choose the state of residence that you're going to be in when you practice, and then you're just going to start typing. An athletic trainer will come up. Anticipated graduation date, we'll just go with May 5th, 2023, and then we'll click continue. And then it'll take us to the next screen. And on this next screen, you'll be able to kind of see the limits of your liability, right? So your per claim about, what's that? Is that $1 million? Yeah. Aggregate 3 million. So you can see it's going to be your annual premium plus fees is going to be $27. That's pretty cheap. So if you, I'm not going to say this out loud, but if you, for some reason, are practicing as a student right now, and you're being hired by like San Diego State to do some camps, which you shouldn't, then you should purchase this very cheap liability insurance. Now, of course, here's an inherent reality. The inherent reality is that is going to go up when you become a professional. So let's look at the fee for that so you all can see. So students aren't as much at risk, right? And so because they're not at much at risk and they're practicing under the scope of someone else. So you say, yes, full time. Yes, I graduated in the last. We'll do this. And we'll do that. So then it's going to give me hopefully a different quote. And that quote is probably going to be a little bit more expensive, right? So we can see it's $91. And so you'll have to, when you graduate, they will automatically switch you over to the new non-student insurance. But you can see the aggregate is still the same. The limits of liability is still the same. It's just the rate goes up because there's a higher risk for you to be sued, kind of like healthcare insurance, right? So professional liability insurance, it's going to cover you. It's going to protect you against claims of negligence. And so it's an extra buffer. I do recommend that you have it. Oftentimes you can negotiate it in the interview process. In other words, it's something that the entity will pay for you. Okay, bottom line, always work on the side of caution and use common sense. I'm assuming all of us have common sense. So if you are uncertain, don't do it and refer out. That's what I would always say to athletic trainers, especially new graduating athletic trainers. So one question that I have for you, based on this lecture that you've just sat through, how do you reduce the risk of litigation as a coach? That's different as an athletic trainer or an allied healthcare profession. If you're going into a different side of the health profession, how do you do that? What are some ways that you would do that moving into a new position? You're moving into a new position. What are some of the ways that you're going to work to reduce the litigation that you might experience as a new athletic trainer working in the field? Okay, there are 4 laws that are important for you to understand and know, and that you can be tested on. And so I'm going to talk through each of these just briefly. The first one is the Family and Medical Leave Act. You, as a staff member or faculty member, depending on what you choose to do in life, you are available for 12 weeks of leave. So there are certain standards for Family and Medical Leave Act. The first is you have to have at least worked for that particular institution for 1,250 hours, and you must have at least worked for them for at least 12 months. So you can't get this unless you've been there at least a year. You can take this for a few reasons. First one is I put serious health condition. So like, let's say you're diagnosed with cancer, for example. The other reason is if you're having a baby. So that would be an example. You could take, I think it's 12 weeks of leave. This is to allow for baby bonding time and all of those good things. And then the other is if you need to take care of a family member. So that would be the other one that's not listed here. So if eligible, you can get up to 12 weeks in a 12-month period. You can take those in bursts, or you can take them all at one time. That's really up to you and the facility that you work for. But this is available to you all. So if a parent gets sick, or if a significant other gets sick, for example, you've been with the company for at least 12 months, then you have 12 weeks of paid leave. The next one is probably most important, and some of us were kind of talking about, like, should we get tattoos? What about our choices in significant others, how we wear our hair, how we dress, all of those things. So the non-discrimination law was placed into effect, and so what this means is people that are hiring cannot discriminate against anyone based on race, creed, sexual orientation. And so I love this law because it really opens up, it creates diversity within the workplace. When in fact when there wasn't non-discrimination laws, you could just discriminate against anyone. And so if we look here, it is illegal to discriminate against someone, an applicant, because of the person's race, color, religion, sex, including gender identity, sexual orientation, and pregnancy, national origin, age, right, disability, genetic information, etc. So really all of us are covered under this scope in some way. Doesn't mean that it still doesn't happen indirectly, but at least it is illegal to explicitly state that they are doing this. And so what I wanted to show you all are some illegal ways to post job advertisements. So if you see these types of things, go ahead and report them. So an example of this would be help wanted ad that seeks only females or recent college graduates, right? Because what's that? Discriminate against age, right? May discourage men and people over 40 from applying and may violate the law. So there are just indirect ways that individuals will try to advertise, but they're still illegal and are improper. The wage and hour laws, their Fair Labor Standards Act, is an act that kind of said anybody that works over 40 hours a week should be paid overtime. Now, of course, you have exempt employees and you have non-exempt employees. Your exempt employees, believe it or not, are exempt from what am I thinking? Overtime. Your non-exempt employees, you have to honor any hour of overtime over 40 hours per week. The athletic trainers here at Point Loma are exempt employees, so they could work 60 hours and they're still getting paid the same. Oftentimes, most salaried positions are going to be exempt positions, but there certainly are times where most hourly positions are going to be non-exempt, right? In other words, for every hour you work over the 40, you get time and a half, and then I think on holidays it's 2 times, and so you'll get paid exactly what you're supposed to get paid. Now the non-exempt positions typically may pay less yearly because they're going to be paying in overtime, whereas the exempt positions sometimes they pay a little bit more because they have to make up for the fact that they really aren't paying for overtime. So there are some advantages either way. Just know to which category the job you are applying to applies. Most athletic training positions, it's a salaried position and you're not getting overtime. You can certainly work to negotiate what that looks like, right? Summer pay, right? So 9-month position with summer pay included. Those would be ways to boost your salary. That is all I have for you all. I hope that you've learned a lot and are thinking about ways in which you'll try or attempt to reduce litigation.